Yes.
May I please? I am on behalf of Mr. P.K. Roy Sudhir, my lord. I beg to mention item number 10, my lord. I have taken consent from other side. It's here, my lord.
No, just wait, because this matter is being adjourned. I think on several occasions.
Yes, my lord. For
Just wait.
partner request, my lord.
Let the matter be followed.
Similar prayer, my lord, in respect to item number 16, my lord.
Item 16.
My lord.
This we can adjourn. Both sides are represented on the prayer made by the counsel to the petitioner. The matter stands adjourned today. Give a date after 2 weeks. List on.
Almost.
For 10, please wait till the matter is called.
My lord.
For item number 10, please wait till the matter is
My
called.
lord, my lord. Almost.
Late, Mr. Lordship. For listing, Lordship, one read appeal.
Listing,
Part
you
of matter, Lordship.
Read appeal.
Lordship.
Read appeal, you'll have to give it to the division bench 1.
Two, Lordship. Board of Revenue, Lordship.
No, we are not the.
No, part of matter, Lordship.
Huh?
Part of matter.
Parted matter. Okay, just check it. Just check it. After that, give it to the court master.
May it please your lordship. Lordship, I beg to mention item number 8, lordship.
It is 2019. Please wait till the matter is called.
Lordship. May I please your lordship. I beg to mention item number 7, lordship. Kindly adjourn the matter for the day.
7 is 2019 matter. Please wait till the matter is called.
Supplementary item 17 for delivery of order.
This writ petition is dismissed. The consequences of the opinion shall follow. The standing counsel for FT matters shall send the copy to the concerned department.
All license.
May I please also? Item 3, my lord. Not with the consent of the petitioner who is outside, my lord, he is not in out of station today, my lord. It can be fixed on 12th of March, my lord.
Item 3 where?
Hmm.
Three
So
is
sorry,
the
my
one
13, my lord.
13.
13. You know, P.K. Roy is out of station. And when KG will appear, he is also in, he will be in Vijay court number 1 today.
No,
13th of March, my lord. Or 12th, my lord.
Both sides are represented on the prayer made by the counsel for the petitioner. Matter is adjourned today. List on 12/3/2026.
Problem, lord.
Item 1 for admission.
Wait, please, your lordship. Okay, I'll just put the facts in 5 minutes and then show how the provisions of law has been violated. And after that, I'll come to the interim judgment, your lordship.
Yes.
Okay, may kindly come to page 106. I've shown earlier, I'm just repeating within 5 minutes, I'll finish it off. This is at page 106, your lordships. Of the writ appeal. Just to show that there was no anomalies as on 27/9/2018. The date is at the
topmost right corner of the page, Your Lordship, 27/9/2018. And in the general remarks on observation column of the table, consumer CTPT and meter has been checked and found satisfactory. So as on 27/9/2018, there was nothing, Your Lordship. Then Your Lordship may kindly come to page 108. This is the meter record book, Your Lordship. They maintain. I have the relevant extract. I have furnished, Your Lordship. At page 109, in the first column, the penultimate remark, Your Lordship, the date is given 1/3/2019. And on the 1, 2, 3, 4, fourth column, same row, last, Your Lordship will find signature is there, and then CMRI taken. So meter reading instrument, Your Lordship, is ever, Your Lordship, is just like one that we use for swiping credit cards and all. So once that instrument is put in the meter, then all the data can be downloaded and it can be analyzed, Your Lordship. And then at page 110, finally, on 8/4/2019, Your Lordship. Your Lordship got it? Page 110, 8/4/2019. Everything has been checked, starting from meter cover, terminal cover, CTPT, extended optical port, and CMR data was again downloaded, Your Lordship. So on 8/4/2019, there were no anomalies, Your Lordship. They put their signature, the inspecting team, and all the meters have been checked. Meter parameters have been checked, Your Lordship. Now, Your Lordship may come to the impugned inspection report, which is at page 111. Date, Your Lordship, will find 11/4/2019. Just after 3 days, when everything was as per themselves only, on 8/4/2019, there were no anomalies. And on 11/4/2019, the remark column is important, Your Lordship. If I may read, general remark on observation of testing inspection.
Mr. Pathak, just an information, if you can find it out, this smart meters, certain data can be downloaded,
My lord.
correct? I read somewhere, but I forgot that this, whatever data that is downloaded by any apparatus connected to these smart meters can also be available in the mobile phone apps, which is there by which the mobile payments are made. So are those data available to a consumer?
Consumption data is available.
Hmm?
Consumption data is available.
No, please ask and then tell us. I read somewhere, but I
In for domestic consumers under APDCL, Your Lordship, in the app. Otherwise, with APDCL,
no, not
It-
that. You see the data that can be downloaded
yes,
has many factors.
not many factors. Only
Now-
the consumption has been made publicly available to consumers through the app.
To the only consumption.
Only consumption. So we have daily consumption, monthly consumption, weekly consumption, various, but only consumption.
Only consumption.
Only consumption.
In continuing that, this current meter reading instrument, CMRI, they can also analyze if there is any anomalies, if there was any fluctuation, everything can be downloaded.
I remember the procedure.
Yeah, Lordship is 7. Now, coming to page 111, Your Lordship, 11/4/2019, the impugned inspection report, Your Lordship, this is what we have challenged. The general remarks, Your Lordship.
It will give you, if I remember it correctly, if my
Lordship.
memory serves me right, it will give you consumption pattern of half hourly, 1 hourly,
Lordship,
and then if there is any what you call disruption, the period of disruption, the energy fall in consumption,
everything.
These things are only there, then some arithmetical, what do you call data, which I won't know. What is that?
The formulas and everything.
That E and all.
Yes, that
The
formula.
Energy consumption
Yes.
square, those things which I don't know.
Yes.
So scientific data is also available.
We can, in general, we can also understand other than the E is equal to MC square formulas, we can understand other things also. Now coming to page 111, Your Lordship, the general remark. As per instruction of GM, so and so, installation is checked and found meter terminal cover seals bearing number so and so are found in tempered condition. So meter terminal cover seals were tempered. Meter cover and terminal cover seal is found in broken condition. CTPT secondary terminal cover seals are found in tempered condition. So tempering was there according to them. They are finding. Hence, it is evident that the metering system is tempered. Up to this much fine, they have found that the metering system has been tempered.
This, that part of argument we remember. You can come up with the reply on loose so that we save time.
Lordship, just only one thing I need to show here, Your Lordship. I'll not show the photographs, Your Lordship. I'll just come to the seizure report at 115, Your Lordship. Just one thing.
115.
115, Your Lordship.
You have said that that seals were not
Seized.
broken
Seized.
seals were not seized.
Yes.
That's
yes,
what you said.
Yes, yes. This part I have shown, Lordship. So Your Lordship remember, so the assessment, thereafter the assessment bill has been made at 121. Only one thing needs to be shown from there. At page 121, the assessment bill. The bill was raised under section 135. Yeah. Oh, उसको याद है. Lordship, this is under section 135 I have shown. Page 121. Why I am emphasizing that it is under 135 is that there is no whisper of section 126 till this inspection report and the assessment bill were prepared, Your Lordship. Entire case proceeded as theft under section 135. As page 121. And last, finally, one more important thing that I need to show now at page 123.
Page 121, what you are saying, that's 120.
One, it's under section 135.
135.
There are other things also, come to it later. This is not as per format 17, but these are technical issues. I'll come to it later, Your Lordship. But then, as of now, it's just to show that this is made under section 135, and there was no element of whisper of section 126 anywhere till now, Your Lordship. And now, if Your Lordship may kindly come to page 123, the last one.
Just a moment.
তেওঁ আছে তো।
Hello, I'd not like to interrupt my learned friend. Certain new grounds have been made during the reply arguments. I'd like some time after he finishes to kindly respond to the same. There is, because this provisional assessment, which is, because this was not a part of his opening argument, that the provisional assessment was made only under 135. No, not, it was not recorded. It was not a part of his opening argument, that it was only made under section 135, Your Lordship. In fact, Your Lordship, the assessment, the provisional assessment order itself refers to clauses 7.5 and 7.4 also. Of the supply code. So, very well, Your Lordship. Just
I'll come to that also, how 7.4.2 came up. It is part of 7.5.4, which relates only to theft. That I'll show you just now also. Now, the other provisions quoted in page 121 is clause 7.544, 7.4.2, and 7.5.3. I'll show it just now. But before that, Your Lordship may kindly come to page 123. Final. After that, I'll not bother Your Lordship with the facts. This is the final thing at page 123. 1, 2, 3, 4, 5, 6, 7. The seventh line from the top, Your Lordship, number of days, Your Lordship will find. This is how the competition is made for assessment of the amount that I need to pay for restoration of electricity. At page 123, Your Lordship. Yes. The 7 line from the top, Your Lordship, number of days. 197. Now, 197 is the multiplier to arrive at the amount which I need to pay for restoration of my electricity supply disconnected. Your Lordship, as I have shown earlier, at best, it can be at most, it can be 3 days, not 197. So any amount multiplied by 3 and any amount, then the same amount multiplied by 197, it will be huge difference, Your Lordship. And this is a statutory provision I am showing. Now I'll come straight to the statutory provision. How they have violated this? By taking 197 as multiplier instead of 2 or 3, Your Lordship, at most. Now, on the basis of this, theft was alleged and my electricity was disconnected before this bill was raised. And before this bill was raised, once the electricity was disconnected, I approached this honorable court by being aggrieved of the fact that my electricity was disconnected by wrong exercise of jurisdiction by the respondent authority, Your Lordship. That was my case, Your Lordship. It is a different thing that later on the alternative remedy matter came up. I'll come to that also. Now, once we approached this honorable court, an interim order was given. I'll just show one part of that order, Your Lordship. At page 137, Your Lordship, what happened, Your Lordship? Interim order was passed. Our electricity was directed to be restored, but instead of restoring, they filed a interim application, Your Lordship. That is IA 1445 of 2019 for modification of the interim order, and that was dismissed on 7/5/2019 at page 137. This I am showing just because this is my case, your lordship. As this is the order whereby the vacation petition was dismissed, their vacation petition. The interim order was on 12/4/2019. This I was filed, your lordship. Your lordship may skip the first part and come to page 139, your lordship. The law has been discussed, and then second paragraph of 139, your lordship. This is was the Honorable Single Judge has said it, your lordship. Pausing here for a moment, it is seen that under section 135 of the Electricity Act, theft of electricity is construed to be an offense for which penalty is prescribed. However, to attract the offense of theft of electricity, it has to be proved that there was dishonest tampering of meter or installation or use of tempered meter, etc., interfering with the accurate or proper registration, calibration, or metering of electric current, or otherwise resulting in a manner whereby electricity is stolen or wasted so as to abstract or consume or use electricity. Upon such detection of theft, their discretion is vested in the licensee or supplier to immediately disconnect supply of electricity. Disconnection to a premise already availing such supply of electricity is a drastic measure. Here I will have to pause, your lordship. This is the only provision under 135(1)(a) where disconnection is provided, your lordship. That is why the Honorable Single Judge says that this is a drastic measure, your lordship. Unless the requirement of section 135 of Electricity Act are complied with, even in a prima facie manner, such discretion may not be justified. Whether an offense of theft of electricity has been made out or not is required to be adjudicated by the special court constituted under section 153 of the Electricity Act, procedure and power of such court being laid down in section 154. The special court is also empowered to determine the civil liability against the consumer who is charged of theft of electricity. However, to initiate a proceeding before the special court, there must be a prima facie case of theft. Mere tampering of meter or tampering of meter per se would not constitute an offense of theft of electricity, your lordship. To constitute the offense of theft of electricity, there must be a dishonest tampering of meter, etc., which results in electricity being stolen or wasted so as to abstract or consume or use electricity in an unauthorized manner. They will have to show that I have consumed it, the electricity in an unauthorized manner. Adverting to the observation of the inspection team dated 11/4/2019, which I have challenged, your lordship, it is seen that the inspection team only found the metering system to be tampered. This is my case, your lordship. They have only found that the metering system has been tampered. Only found, your lordship. Regulation 7.5.2 of the Supply Code deals with inspection, search, and seizure in connection with theft of electricity. As per clause F, in all cases of inspection, a report shall be prepared at site, giving details of connected load, condition, and details of old seals, working of meter, details of new seals, and clearly mention any irregularity notice which may lead to theft of electricity as per the format 16 of the Supply Code. It further says that any damage or destruction to the electric meter, metering equipments, apparatus, line, cable, or electrical plant of the licensee caused or allowed to be caused by the consumer or person so as to interfere with the proper or accurate metering of electricity or for theft of electricity shall be duly recorded in the report. It has to be recorded, your lordship. The authorized officer is also required to prepare a diagram. But by the CMRI data and everything, your lordship, also by reading. And that is why, no, that is not the only meter, your lordship. There is also a check meter at the supplier's end, your lordship. A check meter is always there. At the supplier said, we cannot interfere that meter, your lordship. Under lock and key with the supplier in a different place, your lordship. This is also there in the regulation, your lordship. And in our case also, there was a check meter, your lordship. Suppose in the check meter unit is 2, and I have bypassed it, like your lordship has just said, and my unit, my metering shows 0, then definitely the theft is 2. In the check meter, it will be 2 kilowatt, and my meter will be 0, so I have stolen 2. And if that is not possible, your lordship, how can I have shown, your lordship? I'll come again to that. 135. Only my punishment will be on the basis of kilowatt I have stolen. If it exceeds so much of kilowatt, my punishment will be lesser. If it exceeds more than that, my punishment will be higher. So without the kilowatt, I cannot even be punished. So what is the use of the section, your lordship? How can the intention of the statute be like that, your lordship? So kilowatt is very important, your lordship. What I have stolen is very important. Merely by saying that I am a thief will not be sufficient in any case, not only electricity, your lordship. It has to be there, what I have stolen, your lordship. Just because the windows of my house are broken, I cannot say that a thief has come, your lordship. I'll have to show what has been stolen from my house, your lordship. Now, finally, the last paragraph, your lordship. Having noticed the above, a glance at the seizure report prepared in format 16, dated so and so, particularly the finding and conclusion of the inquiry, will reveal that same is not in terms of regulation 7.5.2 of the aforesaid regulations.
Please never 1%.
Without referring to or satisfying even in a prima facie manner the condition preceding for injunctive power under section 135, conclusion was mechanically recorded that it was a prima facie case of theft of electricity. Of course, this is a matter which should require adjudication at the stage of final hearing. Now, at the stage of final hearing, how this is adjudicated? Again, by a mere. Now, at this stage, your lordship may kindly come to the impugned judgment, your lordship, at page 249. Only one sentence I will show now. At page 120 to 249, your lordship. This is the impugned judgment. After the interim order was passed, the impugned judgment at page 249, your lordship. Only one sentence I will show at this stage, your lordship. I have already shown that while passing the interim order, it was stated that the matter required adjudication at the stage of final hearing. After final hearing, at page 249, in the case at hand, a review of the inspector report reveals that a physical inspection was conducted and prima facie evidence suggesting dishonest abstraction was collected. This much only. Nothing else. Again, a mechanical sentence. How dishonesty, how evidence, what evidence, nothing was mentioned, your lordship. And they have also not stated in the affidavit in opposition in the writ petition, your lordship. And now that interim order that I have shown earlier, your lordship, this was challenged in a writ appeal and that was also dismissed, your lordship. And thereafter, the final judgment was passed, your lordship. Now, your lordship, the statutory provisions, your lordship. Lordship may kindly take up section 135. Thereafter, I'll go to the regulations, your lordship. In the compilation, I have given you. It will be convenient if you lordship take up the compilation. And just mention the page number. Section 135. Huh? Compilation to actually go to asan gets time. Yeah, done. One is asan gets time. No, yeah, done. Page 14 of the compilation. Page 14, 14, section 135. Page 14 and 15, I'll read, your lordship. Thereafter, I'll have to regulation. Theft of electricity. Whoever dishonestly. Number 8, thefts makes or cause, this I am skipping. B, tempers a meter, our case, install or uses a tempered meter, current reversing transformer, loop connection, or any other device or method, which interferes with the accurate or proper registration, calibration, or metering of the electric current, or otherwise results in a manner whereby electricity is stolen. So tempering should be to interfere with the accurate reading or resulting in a manner whereby electricity is stolen or wasted. Now, after C, D, and E, so as to abstract or consume or use electricity. So I'm reading the relevant portion to our case of this section, Your Lordship. Whoever dishonestly tempers a meter which interferes with the accurate reading or otherwise results in a manner whereby electricity is stolen so as to abstract or consume or use the electricity. So these are the ingredients, Your Lordship. My dishonest intention should be there. Of course, that will come at the stage of special courts trial, Your Lordship. Then second part, tempering of meter which interferes with the accurate reading and results in a manner, these two ingredients. And finally, I will have to consume, abstract or consume the electricity. These are the ingredients prima facie has to be satisfied before section 135 is invoked by the respondent authority, Your Lordship. Provided that, first proviso, provided that in a case where the load abstracted, consumed, or used, or attempted abstraction, or attempted consumption, or attempted use does not exceed 10 kilowatt, then the punishment is given. And Roman 2, if it exceeds 10 kilowatt, then the fine and punishments were given. So this uses or abstraction or consumption of electricity by way of theft, by way of dishonest manner of tempering is essential. And that is why the first proviso says that such consumption, if it exceeds 10 kilowatt, my fine and imprisonment will be different. And if it doesn't exceed 10 kilowatt, it will be different. Second proviso and third proviso, I'm skipping and I'm coming to section 1A of section 135. Without prejudice to the provisions of this act. There is a non-obstant clause, whatever is written in the act, that has to be taken care of first. The licensee or supplier, as the case may be, upon detection of such theft of electricity, immediately disconnect the supply of electricity. If there is theft, they can immediately disconnect it. What happens thereafter? How it is to be done is given in the first proviso. Second proviso is important, provided further that such officer of the licensee or supplier, as the case may be, shall lodge a complaint in writing relating to the commission of such offense in police station having jurisdiction within 24 hours. In our case, they have not filed the lodged the FIR before the police station having jurisdiction. They have lodged the FIR, but that police station didn't have the jurisdiction. Now, the third proviso of 1A, where my case lies, Your Lordship, provided also that the licensee or supplier, as the case may be, on deposit or payment of the assessed amount or electricity charges, in accordance with the provision of the Act, shall, without prejudice to the obligation to lodge the complaint as referred to in the second proviso to the clause, restore the supply line of electricity within 48 hours. I'll have to pay something, the assessed amount, I'll come to that, but the relevant provisions of the supply code. Oh, yes, Your Lordship. And Your Lordship may also come to section 135(2), Your Lordship. One earlier, 2. Any officer of the licensee or supplier, as the case may be, authorized in this behalf by the state government may enter, inspect, break open, and search any place or premises in which he has reason to believe that electricity has been or is being used unauthorizedly. B, search, seize, and remove all such devices. Statutory, they have to take the seals. They have LS that is broken. Instrument, wires, and any other physical article which has been or is being used for unauthorized use of electricity. This is statutory that they have to seize the seals, Your Lordship. They haven't done that, Your Lordship. Now, Your Lordship may kindly come to the supply code, Your Lordship. Page 46 first, Your Lordship, of my compilation, Your Lordship. Yeah, I want to. Theft of electricity at page 46. This is the regulation of 2017. I'm referring to it as supply code. 7.5.2 inspection, search and seizure. Then page 47, your lordship. How this has to be done, the inspection and seizure is mentioned here. A, B, C, D, and E. E, your lordship, at page 47. The meters, electric line, electric plant, and other apparatus suspected to be used involved in case of theft of electricity shall be removed and seized
As considered.
as considered necessary by the assessing officer. Now, I have shown that as statutory under section 135 to seize. And then F, in all cases of inspection, a report shall be prepared at site, giving details of connected load, conditions and details of old seals, working of meter, details of new seals, and clearly mention any irregularity notice which may lead to theft of electricity as per the format 16 of this code. They have not done that. This is their regulation, your lordship. Format 16, they have not done it as per format 16, your lordship. They have not stated, mentioned clearly what irregularity has been noticed which led to theft, your lordship. Mere breakage of seal is not theft, your lordship. Second paragraph of F. Any damage restriction to the electric meter, metering equipments, apparatus, line, cable, or electric plant of the licensee caused or allowed to be caused by the consumer authorities to interfere with the proper or accurate metering of electricity, or for theft of electricity shall be duly recorded in the report. This is also missing, your lordship. Now, the authorized officer shall also prepare a diagram. This is mandatory, your lordship. They will have to prepare a diagram illustrating the arrangement found during inspection for theft of electricity, wherever feasible, and such diagram shall be formed on part of the inspection report. This is not as considered necessary by the assessing officer. This is mandatory, your lordship. They have not done this, your lordship. And there was no reply also why they have not, in the affidavit in opposition in petition, they have not replied as to why they have not done this, your lordship. So these are the provisions 7.5.2 regarding to theft of electricity, your lordship. That is why in the inspection report 7.5.2 is mentioned. Now 7.5.4, how the assessment of electricity in case of theft is made. At page 48, 7.5.4, 7.5 relates to theft of electricity. 7.5.4 is assessment for theft, your lordship. And this will also be clear if your lordship reads A, 7.5.4A. Method of assessment of electricity charges payable in case of theft of electricity pending adjudication by the appropriate court shall be same as the case of provisional assessment for unauthorized use of energy specified under clause 7.4.2. Now, this has been amended, your lordship. This clause has been amended, and at page 59, the amended clause I have given, your lordship, 7.5.4A. The amended part is they have added one sentence which is at the beginning. The assessing officer shall assess the amount payable by the person on the basis of the inspection report, and a bill shall be raised immediately. This is the amended. The other portion remains same, your lordship, as the earlier provision, your lordship. Again, I am reading the method of assessment of electricity charges payable in case of theft of electricity pending adjudication by the appropriate court shall be same as in the case of assessment for unauthorized use of energy specified under 7.4.2. Now, what is 7.4.2? Your lordship will find 7.4.2 at page 42, your lordship. This formula they have adopted for theft. Seven point 4.2 provisional assessment. This is for unauthorized use of electricity under section 126. They have adopted this formula for unauthorized use of electricity pending adjudication by the special court, Your Lord. Same formula. So 7.4.2 says that period of assessment is necessary, Your Lordship. Here also they have mentioned that the actual period should have been taken. As I have shown, it cannot be more than 3 days. Now, Your Lordship, since this provisional assessment under 7.4.2 is also the assessment for section 126, a case has been put up by the respondent authority that the 7.5 clause read with section 135(1)(a), the assessment under that section is also an assessment under 126. But this assessment, as I have shown, Your Lordship, it flows from 7.5.4, which pertains to theft of electricity. Not unauthorized use of electricity. This was my case, but since the formula used for unauthorized use of electricity has been borrowed in case of restoration of electricity for theft, the confusion arose, Your Lordship. It is only the formula they have adopted. I have shown, Your Lordship. It is their supply code where they have stated that for theft of electricity, they will assess the amount like 126, 7.4.2. And that is why in the inspection report, these clauses were mentioned. 7.4.2 was mentioned only because it is derived from 7.5.4. 7.5 is theft, Your Lordship. 7.4 is 126, Your Lordship. Our case was that there was no ingredient of 135. So disconnection of electricity on the allegation of theft was illegal. That was our case, Your Lordship.
Since it's covered in the 138, empty circular to the bill.
Wow.
It has not gone before the appellate authority. So this is only at the stage of provisional assessment. They did not file an objection against the provisional assessment. So it has to go before the appellate authority, and then the appellate authority can perhaps decide on these merits, including the discrepancies in the inspection report, the issue regarding the period. Since the appellate authority perhaps may have access to more technical details, Your Lordship, because he can call for the records of the check meter, etc., Your Lordship, if necessary.
Now, Your Lordship, as I have shown in 135, 1A, the third proviso, for restoration of electricity, they have said that the amount has to be assessed as per the provision of the Act. But in the Act, other than section 126, there was nothing regarding assessment of amount. 126 and 135 is different. So a difficulty arose as to how the amount has to be assessed, Your Lordship. And to remove that difficulty, Your Lordship, why I'm saying 126 and 135 is different. Had it been a case that 126 and 126 also includes 135 theft, then they could have assessed the amount under 126. There would not have been any difficulties, Your Lordship. Now the Act is silent about the amount to be assessed under third proviso of 135. That is why the order, removal of difficulty order, your lordship. Page 25, your lordship, of my compilation. The electricity removal of difficulties order 2005. Yes, yes. So the respondent authority has been given the power to make a provision for assessment for restoration of electricity. What they have done, they have adopted the formula used for 126, your lordship. Now, your lordship, whether an appeal will lie, because under 135, there is no provision for appeal. Under 135, theft, FIR will be lost, trial will be there before the special court, either I will be punished or I will be acquitted, and thereafter appeal, your lordship. This is not my case. My case is, what about the restoration of electric supply? Because under 135, if the electricity is disconnected, then for restoration, I have to pay certain amount of money. And if there are some anomalies, some jurisdictional aspects that I have raised here, or if there is some anomalies in the amount, where do I go? They say that I can go before the appellate authority under 127, your lordship. No, I cannot go before the appellate authority under 127, because under 135, there is no provision of appeal, your lordship. And to show it that there is no provision of appeal, I have already shown your lordship that under 135. Now, your lordship may kindly come to page number? Page 60, your lordship. This is their circular of 2021, your lordship. This is the circular, your lordship. At page 60, you will find, your lordship will find, your lordship, guidelines for dealing with theft of electricity under the Electricity Act. This is the guideline they have formulated on 18/5/2021. And the signatory authority is Managing Director, APDCL, your lordship. And page 65 of the circular, your lordship. Appeal to appellate authority, your lordship. E, page 65. Any person aggrieved by the final assessment order booked under section 126 may, within 30 days of final order, may appeal before the appellate authority as per procedure laid down by ARC in 7.4.7 of Supply Code 2017. The second paragraph important, your lordship. However, if a person is booked under section 135, there is no provision of appeal before the appellate authority. This is their circular. The position is clear, your lordship. There is no appeal under 135, your lordship. Now, the distinguish between 135 and 126, your lordship. Sitaram lordship, I have shown your lordship that in Sitaram case, the distinction has been specifically made, your lordship. Sitaram nikalna hai. I've already furnished the copy. I'll just show one paragraph, your lordship. Mera file de. Two 2012 to SCC 10, your lordship. Sitaram. Internal page 119 of the judgment, your lordship. Paragraph 15. just to show that the ratio of the case, 15B in F, your lordship will find. 15B, distinction between section 126 and 135 of the Act. Now at page 123, paragraph 24. Heading is 1B, distinction between section 126 and 135 of the Act. I'm reading paragraph 24. Upon their plain reading, the marked differences in the contents of section 126 and 135 of the Acts are obvious. They are distinct and different provisions which operate in different fields and have no common premise in law. We have already noticed that section 126 and 127 of the Act read together constitute a complete code in themselves, covering all relevant considerations for passing of an order of assessment in cases which do not fall under section 135. Then paragraph 25. Section 135 of the Act falls under part 14 relating to offense and penalties, and title of the section is theft of electricity. The section opens with the words, whoever dishonestly does any or all of the acts specified under clause A to E of section 135(1) so as to abstract or consume or use electricity shall be punishable for an imprisonment for a time which may extend to 3 years or a fine or with both. Besides imposition of punishment as specified under provisions of the proviso thereto, subsection 1A of section 135 of the Act provides that without prejudice to the provisions of the Act, the licensee or supplier, as the case may be, through officer or rank of authorized in this behalf by appropriate commission, may immediately disconnect the supply of the electricity and even take other measures enumerated under subsection 2 to 4 of the said section. The fine which may be imposed under 135 is directly proportional to the number of conviction and is also dependent on the extent of load abstracted. 26. In contradiction to this provision. Yes, in contradistinction to this provision, section 126 of the Act would be applicable to the cases where there is no theft of electricity, but the electricity is being consumed in violation of the terms and conditions of supply, leading to malpractices which may squarely fall within the expression unauthorized use of electricity. This assessment or proceeding would commence with the inspection of the premises by an assessing officer and recording of a finding that such consumer is indulging in an unauthorized use of electricity. Then the assessing officer shall provisionally assess, to the best of his judgment, the electricity charges payable by such consumer, as well as pass a provisional assessment order in terms of section 126(2). Here, Supreme Court, the 3 judges of the Honorable Supreme Court has stated that under 126 is base judgment assessment, your lordship. It is there in section 126 also, statute is also very clear. And by the 3 judges bench of this Honorable Supreme Court, it has been clearly stated that 135 and 126 operates in 2 different fields.
Paragraph 49.
Para 26. Yes, your lordship.
And para 49 as well.
Then the assessing officer shall provisionally assess, to the best of its judgment, the electricity charges payable by such consumer, as well as pass a provisional assessment order in terms of 126(2). This is when the assessment has to be made under section 126, not under 135, your lordship. Lordship? No, your lordship. Under 126, that is what this judgment, your lordship. This is the paragraph 26 starts in contradistinction, your lordship.
He's speaking.
Yes. Yes, if my license says that I can use 120 kilowatt, I cannot use 125, your lordship. That will be unauthorized, your lordship. In that case, 126 will definitely come, your lordship. The provisional assessment will be there. I will file an objection. Then there will be a final assessment, and then finally the appeal under 127. And like I have stated, and I have shown that the three judges bench of the Honorable Supreme Court has stated that this is a complete code, your lordship, regarding assessment of the civil liability, your lordship, under 126. But 135 is different, your lordship. And that distinction is what has been clarified by the three judges bench of the Honorable Supreme Court, your lordship.
Lordship, the ratio of this judgment, perhaps some clarity on the ratio of this judgment, maybe in paragraph 49. Very.
49, what my learned friend is trying to show is that interpretation of statute, your lordship. I'm reading what my learned friend is saying, your lordship, at page 130, your lordship, paragraph 49. Your lordship, after reading paragraph 26, your lordship may also read paragraph 28 to further clarify, your lordship. Paragraph 28, your lordship. Paragraph 28, your lordship, if I may read, your lordship. Section 135 of the Act deals with an offense of theft of electricity and the penalty that can be imposed for such theft. This squarely falls within the dimensions of criminal jurisprudence, and mens rea is one of the relevant factors for finding a case of theft. On the contrary, Section 126 of the Act does not speak of any criminal intentment and is primarily an action and remedy available under civil law. Clear distinction, your lordship. It does not have features or elements which are traceable to the criminal concept of mens rea. Now, after the distinction between section 126 and 135 is completed, your lordship, at page 126, the third ratio of the case, your lordship, 1C, page 126. The ambit and scope of 126. This has nothing to do with the difference between 126 and 135. Now, the three judges bench of the Honorable Supreme Court is answering about the ambit and scope of section 126 with reference to the construction of the words unauthorized use and means. Now, while doing so, what my learned friend is showing at paragraph 49, your lordship, while answering to this, your lordship, the ambit and scope of 126 vis-a-vis the meaning of unauthorized use and means, while answering to this, your lordship, at page 40, paragraph 49, the Honorable Supreme Court has stated, once the court decides that it has to take a purposive construction as opposed to textual construction, then the legislative purpose sought to be achieved by such an interpretation has to be kept in mind. This is about purposive interpretation of legislation, your lordship. We have already indicated that keeping in view the legislative scheme and the provisions of section of the Act, it will be appropriate to adopt the approach of purposive construction on the facts of the case. We have also indicated above that the provisions of section 126 are intended to cover the cases over and above the cases which should be specifically covered under the provisions of 135. Like I have shown in paragraph 26, 29 and paragraph 30 of the judgment, your lordship, 135 and 126 are different. They are quite completely in different field. If it is not theft, if there is no dishonest, then over and above that, that 135, the provisions of 126 will definitely come into play. But this paragraph is relevant as it answers the second ratio of the case, the ambit and scope of section 126 with reference to the construction of the word unauthorized use and means. What is unauthorized use? What is means? I've shown paragraph 49 because my friend is relying on that, Your Lordship. Here also it is specifically stated that the provisions of section 126 are intended to cover the cases over and above the cases which falls under 135. 135 is very specific, Your Lordship. Dishonest, mens rea, theft. Over and above this dishonesty, mens rea, and theft, 126 will cover it. Now, this I have shown Your Lordship the three judges bench, which has very specifically stated that 126 and 135 are completely different. They operate in different fields, Your Lordship. Now, after this judgment was passed, the Orient Metal Judgment, Your Lordship, 2020, 18 SCC 588. My learned friend has referred to the judgment, Your Lordship. The worst sentence is 126. Well. Now, before reading the paragraphs of the judgment, Your Lordship, two things I need to clarify, Your Lordship. While passing the Orient Metal judgment, the Sitaram case, which I have shown earlier, the three judgments, was considered, Your Lordship. It was considered. Yes, but the supply, that removal of difficulty was not. Now, at paragraph 13, page 598, Your Lordship. E, Your Lordship, in between. Yes, just I need to show only one thing. Thus, it is clear that the authorities under the Act are empowered to make a provision and final assessment by invoking power under 126 of the Act, even in cases where electricity is unauthorisedly used by way of theft. Here, the honorable judges found that 126(1) will come into play in theft also, because in this judgment that removal of difficulty order was not shown, Your Lordship. And that is why they thought that the only provision of assessment under 126(1) is also applicable for the third proviso of 135(1)(a).
Yes, it took me. These 235 already was not considered.
Then F, the assessed amount referred to in the aforesaid proviso relates to the assessment which is contemplated under section 126 of the Act. If the removal of difficulty order is not shown, anyone will think that the assessment under 135(1)(a) third proviso is definitely under 126(1).
There is no other plan. Silence.
If that was that simple, Your Lordship, then why the difficulty arose? And why the difficulty had to be removed, Your Lordship?
You would have said.
So this Orient Metal judgment is sub silentio. It was passed sub silentio, Your Lordship, since the 2005 order was not, removal of difficulty order was not shown. And also this is par incurrum, Your Lordship, because in Sitaram case, Your Lordship, the three judges bench of the Honorable Supreme Court has stated that 126 and 135 operate in two different fields, Your Lordship.
Sub silence you for you consider 2005 order and MD circular. Which is the sub silence.
And I have also shown that the circular by the MD, Your Lordship. But MD circular is not here. No? No. That will come, that is relevant for the next, what I am showing, Your Lordship, the C-Veloy steel. that my learned friend has referred to your lordship. The civil law is also not binding because of these two reasons, your lordship. The removal of difficulty order was not shown, your lordship. So it was passed sub silentio. And it again, I'll submit that this is per incuriam because it goes against the three judges bench of the Honorable Supreme Court, your lordship. So these judgments are not binding, your lordship. And in civil law, one more thing is there, your lordship. The MD circular that I have shown, your lordship, which specifically states that there lies no appeal under section 135. That was not shown in the civil law case, your lordship. This is another reason why I'm saying that civil law was passed sub silentio, your lordship. Two important things were not shown. One, the removal of difficulty order, and the other, the MD circular, your lordship. And over and above this, in civil law, a wrong provision of the circular was. Oh, I'm sorry, your lordship. MD order was shown, but wrong provision. That your lordship will kindly come to page 6 of the judgment, your lordship. I'm sorry, your lordship. The MD circular was shown. It didn't win sub silentio, I'm sorry. But it was wrongly interpreted. And 2005 order was not so. MD order that I have shown your lordship, which is at page. MD order, apna properly think the page number bata. The MD circular at page 65, your lordship. It starts at page 60. At page 65. This is clause E, your lordship. We'll find, not F. To show that there lies no appeal, clause E was referred. But while passing the judgment, civil law, your lordship, clause F was discussed, not clause E. Clause F didn't have any relevance to that fact of the case, your lordship, of civil law, your lordship. Clause page 6, your lordship, of civil law judgment. Paragraph 6. Paragraph 6 is at page 5. Oh, at 9. I'm reading from a different copy, your lordship. ये लड़का नहीं है क्या अपने पास? itu kuntu hari petition to nih. Pintu defination kuntu. Itu read petition tuh. Appeal tuh dia na itu. Oh, no, itu di sana. The appeal order, your lordship. Read appeal 286, your lordship. Civil law. Paragraph 6. Your lordship got it, your lordship. This is not reported, your lordship. Here, I'm reading paragraph 6, your lordship. We have heard so-and-so learned senior counsel for the appellate in great detail. He was primarily answering the objection raised again by Mr. So-and-so learned counsel for the PDCL on the maintainability of the writ appeal in view of statutory remedy provided under section 127 of the Act. Mr. So-and-so will argue that the order dated so-and-so of the assessing authority is not an assessment order under 126, but it is actually an order under 135 of the Act, whereby theft of electricity has been alleged and therefore it will be matter covered under 135 of the Act. Now, this is important. He would also refer to the guidelines framed by the APDCL White Circular dated 18/5/2021, which I have shown your lordship. Referring to clause 11 of the aforesaid guidelines, which deals with unauthorized use or theft of electricity, he would argue that as per subclause 5, subclause F of clause 11 of the guideline, no remedy lies. And then it went on and that The learned counsel will argue that in clause 11.5 of the aforesaid guideline, it has been stated that no civil court shall have jurisdiction to entertain any suit or proceeding. But this was not the argument, Your Lordship. The argument was that the appeal didn't lie, and that was in 11E, not F. Your Lordship may kindly come to page 65 of my compilation. That will clarify, Your Lordship. In E, it is mentioned, however, if a person is booked under 135, there is no provision for appeal before the appellate authority. No appeal lies is E, not F. So my humble submission is that Orient Metal and C. Valoy both are not binding. Precedents, Your Lordship. And the three judges bench of the Honorable Supreme Court, the Sitaram case is binding, which specifically states that 126 and 135 are different, Your Lordship. And that Sitaram was also upheld in Kerala State Electricity Board versus Thomas Joseph, Your Lordship. नहीं तो ये वो दे देंगे, हो गया सेम चीज क्या पढ़ाना है बार-बार बोलते दे देंगे. I'll furnish a copy of that judgment, Your Lordship, and I'll mention the paragraph also. Thomas Joseph. क्या रह गया? सही है क्या? Para 54 2. What copy देना? I'm referring one more judgment, Your Lordship. Kerala State Electricity versus Thomas Joseph, Your Lordship. I'm giving copies of the judgment, Your Lordship, and mentioning the paragraph numbers where Sitaram case has been upheld, Your Lordship. I shall not bother again. Same paragraphs, Your Lordship. I'll not read again, Your Lordship. And I'll also provide a few judgments regarding sub-silence, Your Lordship. And there is a landmark judgment of Your Lordship, Your Lordship. In fact, the Ganesh Chandra Pathak judgment, Your Lordship, in read petition 4244 of 2018, it covers all the aspects of sub-silence, Your Lordship. What is sub-silence? Ganesh Chandra Pathak पढ़ा लेता है और क्या पढ़ाना है कुछ और? देखिए क्या हो पकड़ो 370 फिर चिंता को पकड़ेंगे विकास है Your Lordship, that Ganesh Chandra Pathak case, Your Lordship. Paragraph 18 at page 9, Your Lordship. Lordship. Yes, Your Lordship. Judgment दिखाना है 130. গণেশ এইটো submit দিছো। কপি এটা নাই এটা এইটো আৰু আছে নেকি চব? নাই।
ঠিক আছে। ঠিক আছে।
পেনটো দেখোন আৰু পেন আছে নাই? Paragraph 19, paragraph 18, Your Lordship, of the Ganesh Chandra Pathak case at page 9, Your Lordship. In the quest for justice, it is deemed appropriate to examine whether the doctrine of sub silentio can be invoked under the facts of the present case in respect of the judgment and order that is so and so passed by this court in WPC so and so, insofar as it relates to interference with DPC that is so and so adversely affecting the petitioner. In this regard, it would be appropriate to refer to the explanation of the concept of sub silentio at 153 by Professor P.J. Fitzgerald, editor of the Salmon on Jurisprudence, 12th edition, in these words, within quote. A decision passes sub silentio if, in the technical sense, that has come to be attached to that phrase when the particular point of law involved in the decision is not perceived by the court or present to its mind. The court may consciously decide in favor of one party because of point A, which it considers and pronounces upon. It may be shown, however, that logically the court should not have decided in favor of that particular party unless it also decided point B in his favor, but point B was not argued or considered by the court. In such circumstances, although point B was logically involved in the facts and although the case has had a specific outcome, the decision is not an authority on point B. Point B is said to pass sub silentio. In our case, appeal lies under 136. In cases of theft under 135 is point B, Your Lordship. Paragraph 19, upon examining the said concept, it is seen that the principles of sub silentio has been elaborately discussed by the Supreme Court of India, amongst others in the case of so-and-so, so-and-so, so-and-so. It appears that when a matter is decided without argument, without reference to the crucial words of the rule, and without any citation of authority, would not be binding and would not be followed, Your Lordship. So civil law and Orient Metal, as I have shown, Your Lordship, are not binding or needs to be followed, Your Lordship. It has been held that precedents, sub silentio, and without argument are of no moment, Your Lordship. This I am referring, Your Lordship. Now coming to the impugned judgment of the Honorable Single Judge, Your Lordship. It started page 253. 235, sorry. We are agreed by disbursement, your lordship. I'll come to straight away to page 243, your lordship. Paragraph 19. The primary controversy in the present case is whether in cases where theft is alleged, assessment proceedings under section 126 are permissible at all, or whether the matter must be exclusively dealt with under section 135. So this is a controversy that arose during the argument of the case, your lordship. But this is not our case, sir. This was never our case. Our case was that the disconnection of electricity by invoking 135 when they couldn't was without jurisdiction, your lordship. That was our case, your lordship. And it was at most, it can be a case of tempering of seal under section 138 that I had already shown, your lordship. Now, paragraph 23 to 27, your lordship. It started page 245. Section 135, while addressing the theft of electricity, empowers the disconnection of electricity upon detection of theft under section 135 1A and criminal prosecution. The special code dealing with the trial of an acquisition of theft of electricity under section 154 5 and 6 is vested with jurisdiction to determine civil liability. Therefore, such power can only be exercised after conviction in the criminal trial. So up to this much is fine, your lordship. The civil liability will come only after the conviction, your lordship. And the interim measure I have already shown. The Electricity Order 2005 mandates that ERCs to establish a procedure for incorporating into the supply code the determination of such charges payable by the party pending a decision by the appropriate court. Such a mandate leaves no room for doubt in the court's mind that a procedure is to be laid down in the electricity code for assessing electricity charges pending the determination of civil liability by a special court under section 154 of the Act in the prosecution of theft of electricity. Such a prescription nowhere mandates or bars the Commission for adopting the procedure of assessing electricity charges under 126 of the Act. So far as it relates to the method of determining of such charges, there is no mandate for laying down a separate procedure in exclusion of the procedure under section 126 of the Act. I'm challenging this part of the judgment, your lordship. It is very clear from the 2005 order itself, your lordship. The formula they have adopted, it's a different thing, but it cannot be related to 126, your lordship. In the state of Assam, in compliance with such a mandate of the order, the Assam Electricity Regulation Commission has admittedly notified in the supply code that the procedure under section 126 shall be applicable for determination of charges payable by the party alleged to have committed theft of electricity pending determination by the appropriate court. It's a different thing. 7.4.2 of the supply code also relates to 126, but that will automatically not push us to 126, your lordship, from 135. Above that, such a prescription made by the ARC is not under challenge in the present writ petition. That being the position, in the considered opinion of this court, the respondents are within their competence and jurisdiction to proceed under 126 of the Act to assess the electricity charges arising from the alleged theft of electricity, which was already been done in the case. Merely adoption of a formula under 7.4.2 of the supply code will not mean that this is a proceeding under 126, your lordship. And that is not challenged in this proceeding in the writ petition, your lordship, because it came up at a later stage, your lordship. The court is also in agreement with the argument of the respondents that when the procedure for assessment is under 126, the natural corollary is that an aggrieved party shall have the right to approach the appellate forum under 126(7). So if the assessment provisional start from the beginning, from the inception, if the assessment is under 126, naturally 127 appeal lies. But merely by adopting a formula under clause 7.4.2 of the supply code, which incidentally also pertains to section 126, will not give us the right to file an appeal, Your Lordship. Appeal cannot be a natural corollary, Your Lordship. Appeal must be a creation of statute, Your Lordship. It is not an inherent right like that, the right of a sue, Your Lordship, right to sue, Your Lordship. Now, this is what is regarding the part of alternative remedy. Now, regarding the part of jurisdiction, I have already shown, I'm showing again at page 249. In the case at hand, a review of the inspection report reveals that a physical inspection was conducted and prima facie evidence suggesting dishonest abstraction was collected. This much only. As to why they have the jurisdiction, Your Lordship. The statutory provisions, the regulations that I have shown, Your Lordship, just now, Your Lordship, were not discussed, Your Lordship. Applied in the present case and for the reasons recorded herein above, the jurisdictional fact for proceeding with and assuming jurisdiction under section 126 of the Act is already present in the inspection report. It was not present, Your Lordship. I've shown, Your Lordship. It was under 135, not under 126. And why 7.4.2 was mentioned? Because it flows from 7.5 of the supply code. 7.5 pertains to theft of electricity, Your Lordship, of the supply code, Your Lordship. And merely because in 7.5.2a, clause 7.4.2 is mentioned, it will not automatically be diverted to 126, Your Lordship. It cannot be, Your Lordship. Thus, the arguments on the merit of the inspection report and the evidence collected may be a subject matter of determination either before the assessing authority under section 126 of the Act or before the appellate authority under 127 of the Act, more particularly for the reason as recorded herein above that the jurisdictional facts are present in the case, clothing the assessing officer with the jurisdiction, Your Lord.
There is no appeal provision for.
Last paragraph, Your Lordship has already gone through this. Therefore, in the totality of the matter, this court is of the unhesitated opinion that the petitioner is having an efficacious alternative remedy under section 127. So for the same relates to the impugn assessment, more particularly when the ARC has already notified in the court and in terms of difficulty, removal of difficulty 2005, adopting the procedure prescribed under 126 of the Act. So far, the same relates to assessment of charges pending determination by special court exercising power under section 154 of the Act. So, Your Lordship, I'm just concluding my argument, Your Lordship. As stated above, stated earlier, Your Lordship, my case is that the assessing officer didn't have any of the ingredients of section 135 not present, Your Lordship. Lordship.
These are the few judgment points. My lord, I'd only like to respond to the issue of, since the issue of very well. Because the issue of subsidentio in per incurium, that was only raised during the reply arguments of the Supreme Court judgment. I'd like to respond to that. I will be very fair. Okay. On my lord. In fact, I am carrying a judgment, Your Lordship, Sugandhi Suresh Kumar. There, the Supreme Court has decided this issue on whether a High Court can invoke the principles of substantiatio or in per incurium against a judgment rendered by the Supreme Court. Perhaps that may, I'll try and find out this judgment as well. Yashoda. Very well.
Lordship, can it be on Friday, your lordship?
Yes, sir. Thursday would be perhaps more.
Thursday होगा यही बोलेगा मैं उसमें करूँगा तुम इसमें करूँगा okay lordship. Lordship.
Mr. Dasgupta, you are waiting for which item?
Item number 11.
Mr. Sharma, can you upgrade and take it up? You don't want senior counsel to wait.
Oh,
Well, the impugn order is at page 42.
Yeah, put it two, otherwise it will be- Just wait, we'll get the file.
Okay, so. Yes. 23 or no? 23 references. Sorry, 2003 references. But. Page 42 minute. Number one thing that I would like to mention before your lordship at the very beginning, that it appears to me the matter was referred to the Foreigners Tribunal in the year 2003. That is very much clear on the third line. The case has been referred to by the Superintendent of Police Border, Lakhimpur, North Lakhimpur under Order 2 of the Foreigners Tribunal Order 1964 by District number 146 of 2003. So it is very much clear that the matter was referred in the Foreigners Tribunal in the year 2003. Well, at that point of time, there were two tribunals. One was Foreigners Tribunals and other was illegal migrant determination by tribunal. The person concerned who entered in Assam within the stream of 1960 to 71, they were adjudicated by the Foreigners Tribunal. And the person concerned who entered in Assam after 25/3/71, they were adjudicated in the illegal migrant determination tribunal. So far this case is concerned, it is to be examined whether he has entered before 1973 or not. After 1966 and before 1973 or not. Now, if your lordship come to the finding at the page 47. Considering the entire materials on record, I am of the considered opinion that the proceeding, namely Sri Ramani Mohan Devnath, son of late Satyendra Devnath, as police reference, is a foreigner who enters India within bracket Assam illegally from the specified territory of Bangladesh after 25/3/1971. He may be pushed back or deported in the specific to the specific territory in exercise the power under section 13 subsection 3 subsection 13 be kept in interim such and such. So there is an apparently there is an error. He was called upon to decide whether he entered before 25/3 to 1971 and after 1961. If that might be the terms of reference. No, I could not go through the main record, but it appears to me. Now, if that being so, it must be a case for remand. Even if we do not go the other.
Dasgupta, the reason is that this inquiry was made in 2003, matters referred to IMDT Act. Under to the Illegal Migrants Determination Tribunal. But the reference was whether he's an illegal migrant of post 25/3/1971. But then after Sarvanan Sonowal, the proceedings in IMDT were all stalled, and thereafter this reference was made before the was again made before the foreigners tribunals.
No,
Yes.
this reference was made under the foreigners authority.
No.
Yes,
No.
yeah, this
Mr.
case has been.
Dasgupta, will tell you what has happened. What has happened is that it was an IMDT reference. But after Supreme Court has transferred it, it came to the foreigners tribunal.
Yes, that is the usual case. When the matter was transferred to IMDT tribunal, but it appears to me, I may be wrong, this case has been referred by the Superintendent of Police Border, Lakhimpur, North Lakhimpur, under
No, it has,
order 2 of the Foreigners Tribunal.
that's why what has happened, it was sent to IMDT, thereafter it was, all those were, by the Supreme Court directions, they were sent back.
No.
And again, a fresh reference was made to the.
At the relevant point of time, the orders were referred by 2 modes. One under the provisions of the Foreigners Act through
Show you the record.
Foreigners Tribunal
Dasgupta.
orders 1964.
This is something we have been looking at day in and day out. We'll send you the record. We have put 2 flags. First, see the flag.
I have not gone through the record.
Which is first see the flag which is down below, and then come to the top flag.
I could not go through that because, but it is stated so.
Has to be. But once you see, once a matter is taken out from my court and sent to the court of my esteemed sister, what will she write? She will write that the matter has been referred to me for adjudication.
Now, under
The
what
past
provision?
history is not required to be written. You look at the second flag first. Reference to IMDT. Down below signed by SP. Mr. Sharma, so the SP's sign. Yes. This is SP's signature. Correct.
Okay.
Now come to first flag now. First order. Supreme Court says transfer. Therefore, SP will have to make a transfer.
No, no, sir.
Past history is not required
After
to be
two
recorded.
thousand five, all the cases are to be adjudicated in the foreigners tribunal. But when the reference was made in the year 2003,
It was never made. It was the reference I showed you is to IMDb.
Chairman and the. One, B, and.
And you turn the page, 1 or 2 pages, you will find a form.
oh, yes,
Mr. Sharma, there's a form.
yes, yes.
And in the form, in the 3rd page, you will find the references post 25 in 1971. That-
Yes. Illegal migrant determination children.
No, the form, inquiry form, Mr. Sharma. Going to. Yes.
Form one.
3rd page, column heading or something.
Last of the form.
ठीक है सर, ठीक है.
So let him show it to you because he is acquainted. He will take lesser time. No, that page you open, only that.
No, no, I have understood. No, but it appears to me from the writing of the judgment, in the year 2003,
Yes, yes.
under the foreigners tribunal order.
That's why we showed you the first order sheet.
It disciplined.
Yes, this one. So it was suspected to have. the inquiry-
That's all. Now,
No, no,
now.
just here the.
No, ठीक है. पैसा है, कम पैसे से. Here in this case, it appears that the petitioner exhibited a number of documents,
6 documents.
6 documents.
6.
All these documents were obtained through computer. But one thing is that, my lord, he has to file a certificate under section 65B of the Evidence Act. But that was not filed by him. That is one of the irregularities, my lord, that has been pointed out by the learned presiding officer. But one aspect of this case is concerned, my lord, that he has also exhibited one document, that is Jamabandi. That is Exhibit J. In this Jamabandi, my lord, sorry, yeah, periodic Kiraj Patta, page 49. His mother's name, Hirani Sarkar. His name, Ramani Devnath, serial number 7. That is with respect to the plot of land. That is at page 49, my lord. But this patra was, whether this patra was executed or not, that is not very much clear. Patra was on English, isn't it? Judgmental. Babu, no,
Not exhibit.
this certificate was a paragraph 10 of my question. That the petitioner inadvertently the said certificate could not be produced before the tribunal. Your lordship may be pleased to consider the same certificate. That certificate is not. but the sale deed was successful.
It is
Hmm.
valid from 2009 to 2029, Lordship,
What do?
this patta. Prior to that,
Sale deed was done. Sale deed was done. He submitted digital copy of the voter list period of his father, 1971. NRC also, 1971. He has to file a certificate. From what, by stating the particulars of the computer from which it was extracted.
Lordship. Yes.
He only furnished the document. He was a good person, okay?
Yeah.
Very common.
Yes.
Mhm.
Yeah, we have done some.
No, the written evidence.
We have to leave it for a night, huh?
Your number happens. Exhibit numbers are there by separate file. Cross examination. Oh, exhibit. He asks all these questions again. Those.
Proceed. This is also in NRC document, exhibit 3 and 5. Exhibit 3 and 5 are NRC document. Yes. No.
Voter list is voter list is there.
Yes, NRC documents are not signed by the member of the.
School certificate. School certificate. Yes, yes, yes. Only one witness was examined. Others में मिल जाती है. তো সেলই দেখিনি বিষয়
তখন আছে NXL করছে exhibit করা।
না সেলই দেখা আছে সেলই টাকা যেতে আছে unregistered or the unregistered no
জমাবন্দি এখন
জমাবন্দি আছে না এখন জমাবন্দি is for the exhibit
not agree.
জমাবন্দি is not exhibition বলো তুমি স্যার তুমি কই জানো তুমি কই দিও আর নাম তো আছে তো কই জানো You have been strictly to seriously. Okay, question. It's only to plan. Other. There is a cell day, register cell. There is a register. Huh? Hmm. You know, the name of his father. Chaitanya. Yeah, teacher. 68. 16 to 68. Eternity. This one again. Document is very global. Any computer to power. Computer to power. Document.
এইভাবে চাকরি করতে এটা তো এগ্রিমেন্ট করেছিল কি এগ্রিমেন্টের প্রবলেম আমার লিঙ্ক তো লাগে লিঙ্ক তো লাগে লিঙ্ক
এইটু নয় বলছে পাওয়া যাবে না উদ্যোগ সম্ভব হবে
না রমণী মোহন দেবনাথর সেখানে চন্দ্র দেবনাথর লগত লিঙ্ক কি আছে
না একটু পিছার কথা কিন্তু ডকুমেন্ট কিন্তু পাওয়া যাবে
ডকুমেন্ট পাওয়া যাবে একটু এগ্রিমেন্টের ডকুমেন্ট অলরেডি প্লেস করেছি
সার্টিফিকেট নোহার কারণে সার্টিফিকেট নোহার কারণে ডিসকার্ড করেছে জাজমেন্টটা দেখি সুপ্রিম কোর্টের জাজমেন্টটা দেখা এটা
Dasgupta, we are not finding any connect.
Only thing is that whether this document which he has exhibited, that can be ascertained at this stage also.
State is not disputing any of the document exhibited. But the only problem is that the documents exhibited, we have told you, you look at 1972 voters list, it is Chatendra Chandra Devnath and Kiran Bala Devi. 1997, it is Kiran Devnath and Ravani Devnath. So how do you-
Minor discrepancy, similar, only
No, no, no.
Pala and
we are not on that. How does it connect to to anyone whose presence is recorded in India prior to 25 to 1971? That is not there. Even if we accept everything, then also the voters list of 1972. It falls short of 25 to 1971.
Huh?
71.
Or it will be fixed there for tomorrow, Milan. In the meantime.
ওই session footage যেতে লাগবে না?
উনি কি ভেরি ডিফিকাল্ট নাকি?
হ্যাঁ?
উনি কি বললেন?
একটা কেস আছে, দুইটার সময় ফিক্স হয়ে আছে।
Item
number 8 मिला, hearing list मिला, तो मैं फिर भी ठीक है ना?
Yes, my lord. He has stated everything, my lord. Only the brother's name has not been mentioned.
Lordship, my humble submission is that petitioner is
My lord. My lord. My lord, I want to rely one judgment, my lord, that my lord, I want to rely only on Sirajul Haq judgment, my lord. 2005 GLT, 2019 5 SCC 534, 5 SCC, page my lord 534. Paragraph, my lord. This is regarding, my lord, minor discrepancy in the voter list, my lord. Yes, my lord.
Yes, proceed. Lordship, petitioner is totally failed to establish his relationship along with his projected parents, Lordship, whose name is reflected in the year of 1966 and 1970, Lordship. Lordship, 1966, Putali stays page 14, Lordship. Shamsher Ali, Kulbanu V. Abdul Mum Zubeda Khatun, page 14, Lordship. Then, yes, Lordship. And after 1966, 1970, voter list has been placed by the proceeding, page 16, Shamsher Ali, Ah Mum Zubeda Khatun. And Lordship, after 1970, Lordship, if we see the WS Lordship, totally fake statement has been given by the proceeding that my father and mother died after 1970. And Lordship, so after 1970, Lordship, there is no other connection, Lordship. Continuity is not there after 1970. And after 1970, Lordship, 1975 voter list has been placed by the proceeding, where Lordship proceeding here becomes Usaid Ali, and here Lordship on earlier voter list, here one Abdul Mum was reflected, but here Lordship Abdul Sum was reflected, where Lordship his projected father's name is written as Samir. Everything has been everything's are different, Lordship, in this voter list, Lordship. And Lordship, what remains, Lordship, only brother's evidence remains and Gaura's certificate remains, Lordship, to establish his connection with his projected father, Lordship. And Lordship, regarding brother's evidence, Lordship, what our High Court says, just I am reading some paragraph of Lordship, 2017 to GLT. Lordship. No, 75. 70 also, dear Lordship.
70 also there, my lord.
Oh. Exhibit ASD 75, B 70, and C 1966. D Gaubra certificate, only these documents are annexed, exhibited, Lordship. And yes, Lordship. But in 1975, Shamsher becomes Jamsher. Page 18. And another new entries come, Lordship. Asum, son of Samir, not Shamsher or Jamsher, Lordship. Then, and
Volume below.
2017 to GLT 1076.
17.
1076.
Lordship.
Yes, my lord. My name is Abdul Hussain, my lord. Name has been wrongly mentioned as Hussain Ali.
Yes, Lordship. So, Lordship, I am relying nominally case, Lordship, 2017 to GLT 1076. Rohimali, no, nominally, MOMIN. Two thousand seventeen to GLT 1076.
076.
1076, Lordship. Para 12, Lordship. It is stated that in this written statement of the petitioner was wholly inadequate and did not disclose any material facts as noticed above. It was allegation of the state that petitioner was a foreigner. Therefore, as per mandate of section 9 of the Foreigners Act 1946, it was bounden duty of the petitioner to have disclosed all the material facts which are specifically within his knowledge in the written statement, but he did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding name of his mother and identity of his grandparents, both paternal and maternal. He did not mention anything about his brothers and sisters, nor about his marital status. On the basis of such written statement, it cannot be said that petitioner had stated anything substantial to show that he was not a foreigner but a citizen of India. And Lordship, it is settled position of law that para 13, it is settled position of law that where a party fails to set up a case in his pleadings, he would be debarred from adducing evidence in his support at this stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. So, Lordship, here, Lordship, in this case, Lordship, petitioner nowhere stated that he has a brother whose name is Abdul Mum, Lordship. And Lordship, apart from that, Lordship, there is no such voter list where his
projected brother's name and his name is reflected together, Lordship. So, Lordship, then Lordship. Lordship, again I am reading Lordship, para 17 of the said judgment. What Honorable Court has observed, Lordship. Reverting back to the written statement, it has already been noticed that there was not a whisper by the petitioner that he had any brothers and sisters, not to speak of disclosing their names and their particulars. Therefore, the sudden appearance of Umar Ali in the witness box as a brother of the petitioner has to be looked with suspicion, and this suspicion is further forfeited by the fact that in the 1997 voter list, the name of Umar Ali did not appear along with the petitioner. That apart, so and so, Lordship. So, Lordship, here, Lordship, brother's evidence cannot be treated as a valid evidence, Lordship, to prove that the petitioner is not a foreigner, Lordship. And apart from that, Lordship, what Gaubudha stated, Lordship, only to help the petitioner, he issued the certificate. That much evidence was given, Lordship. So that cannot be accepted, Lordship. Gaubudha knows everything, that he has a proceeding before the tribunal, and Lordship, Gaubudha only on the basis of Lordship what Gaubudha has stated, Lordship. Then 41. Lordship. Yes. Lordship. No, Lordship. Because Lordship, it is not based on any record, Lordship, and this is necessary, Lordship. Only someone come and ask to Lordship. Lordship. But in case of foreigners case, Lordship, it is not permitted, Lordship. And Lordship, what Vijayada's case has stated, Lordship. Two 2018 3 GLT, Lordship. 118. It is tried that mere para 17, Lordship. 2018 3 GLT 118. Para 17, Lordship. It is tried that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The facts in issue would have to be proved by the proceeding by reducing documentary evidence which are admissible and relevant. And Lordship, again, Lordship, regarding Gaubura's certificate, Lordship, I am just reading some paragraph of 2018 4 GLT 373, Lordship. 18 4 GLT 373. Romila Khatun, ROMILA. Romila KHATUN Khatun. Decided on 8/6 2018. Passed in WPC 3807 of 2016. Paragraph numbers are not given, Lordship. Relevant. Para 22, Lordship. This paragraph is quoted on the basis of Gauhati's certificate. It is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of content is another. Not only the document would have to be proved, but its contents would also have to be proved. That apart, the truthfulness of the contents of the document would also have to be established from record. A document or contents of the document cannot be proved on the basis of personal knowledge. So, Lordship, if Gaubura's evidence and brother's evidence goes, Lordship, nothing will remain, Lordship, to prove his citizenship. Apart from that, Lordship, in Aziz Mia's case, Lordship, regarding voter list, what is quoted, Lordship? Just reading. 2023 4 GLT 246. So 2023 4 GLT 246. Para 14, Lordship. We are constrained to observe that mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father is not a conclusive proof, and that by doing so the person discharges the burden that he is not a foreigner. This is because there is also a further requirement to prove that person who is reflected in the voter's list relied upon this actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. And in this case, Lordship, proceeding is lack of such materials by which his claim can be substantiated. By linking the person whose name reflected in the 1966 voter list, Lordship. Yes, Lordship. And in Sirazul Haq's case, what my learned friend has stated, Lordship. Here, facts and circumstances are different, totally different, Lordship. (2019) 5 SCC 534, Lordship. Para 2 and 3. We have heard the learned counsel for both the sides extensively and have gone through the documents produced by the appellant ourselves. On a perusal of the same, we find that a number of documents have been relied upon by the appellant, starting with the voters list of his grandfather Kematullah in village Sotubasdani. There is no doubt that the grandfather's name Amatullah appears as Amatullah throughout the documents. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancy found is that in some of the documents, Kefatullah later becomes Kematullah. However, what is important to note that his father's name Amatullah continues as Amatullah, and other family members associated continued as such. So, Lordship, in this case, although there are so many discrepancies found in the voters list, Lordship, after 1970 or 1975, there is no continuity apart from the discrepancy. So this case cannot be accepted, Lordship, in respect of present case, Lordship. This is my humble submission, Lordship.
My lord, I want to add one more judgment. My lord. That is, my lord, 2005 Sarvananda Sonowal one case, my lord, one. There are 26, my lord. 2005 5 SCC. Page 665, para 26, my lord. My lord. My lord, as my lord learned friend has stated that I have not stated any material facts in my WS, my lord. But so far my knowledge is goes, my lord, I have stated everything, my lord, except my lord, brother's name, my lord. And so for the voter list are concerned, my lord, except my lord spelling mistake, my lord, all other contents are, my lord, consistent, my lord, in the 3 voter list, my lord. The house number, the name of the villages, even, my lord, if you compare the ages also, my lord, your lordship, that is consistent, my lord. My lord. My lord. Yes, my lord. After 70, my lord.
After 1971. Yes, Lord. Yes.
That is true, my lord. Hmm. My lord. My lord. Highly obliged. My lord. Open.
For hearing, item 4.
Another day, because Mr. Pine was handling this case, so he is not physically fit. No problem. After 7.
After 7. My lord, maybe 17, my lord. My lord. Yes, my lord, I am voice down, my lord.
Mr. Pine also very.
So,
You start enough. In this letter also, you start enough. Please.
I will inform. That's what.
my lord, my lord. There was another matter, my lord, the lordship fixed it today, my lord, that 19. 20, my lord. That, they sought time, my lord, for completion of investigation, my lord.
Lordship,
This number.
That may also.
He also appear also. In both cases, he study not will appear also.
My lord. My lord.
Possible, he fixed on his then also 26. Lordship. We will available. Okay. Lordship.